Start para. Feeling aggrieved and dissatisfied by order dated 15/12/2021 passed by the learned Joint Civil Judge Senior Division Thane below application (Exhibit 5) in Special Civil Suit number 367/2021, the appellants (defendants) filed present appeal. By the impugned order, the learned trial court was pleased to allow the application, thereby directing the respondents (defendants) to vacate the suit room. Para. The suit property, that is, a room measuring 12 into 20 feet, is said to be constructed by the respondent herein, that is, plaintiff. The entire property was consisting of 4 rooms. One room is in possession of daughter of the plaintiff. Another room is in possession of second wife of plaintiff's husband. One room is let out on rent, and in fourth room the plaintiff was residing along with the defendants. The defendant number 2 is the second wife of defendant number 1. The defendant number 2 falsely implicated plaintiff in 498, a complaint wherein the plaintiff got acquitted. The defendants together harassed and driven out the plaintiff from the suit room. Therefore, present suit seeking declaration that the plaintiff be declared absolute owner of suit room, permanent injunction, that is, the defendants be permanently restrained from entering the suit room, and by way of amendment, the relief of possession is sought. Pending the suit, the application (Exhibit 5) is filed seeking mandatory injunction in the form of restoration of possession of the plaintiff in the suit room. Para. The defendants appeared, and by filing written statement Exhibit 17 and 18 opposed the suit as well as Exhibit 5 application. It is contended that the plaintiff and defendants were residing in the suit room. It was purchased by father of the defendant number 1. The father purchased 3 rooms and 1 shop from his own income. The father died in the year 1984. After his demise, the plaintiff started harassing the defendants. After the demise of father, the plaintiff do survive on the rent received as against 1 room and shop which were let out. In the year 2002, the plaintiff outstayed the defendants. However, thereafter, the plaintiff and defendants again started residing together. The defendant number 1 is not having any place to reside, and he has no any other source of income except the earning from auto rickshaw. The defendant number 1 bore the cost of maintenance of the plaintiff, which includes her cataract operation. The defendant number 1 do take care of the plaintiff. However, at the instance of sister, that is, daughter of the plaintiff, the defendant is harassing the defendant. Thus, the defendants prayed for dismissal and rejection of the suit as well as TI application. The learned trial court was pleased to direct the defendants to vacate the suit room by passing the impugned order, hence present appeal. Para. The learned advocate for the plaintiff strongly opposed the appeal, contending that the defendants are misleading regarding the room which is in possession of sister of the defendant number 1. Thus, as per the ratio laid down in case of Dilip Singh versus State of UP and others by Honorable Apex Court in Civil Appeal number 5239 of 2002. If the facts are concealed, the party is not entitled to be even heard on merits. However, with due respect, the plaintiff failed to establish as to what facts are concealed, and thus the authority is not applicable and helpful to the plaintiff. Para. It is contended that the suit room is purchased by the plaintiff and thus the act of dispossession was illegal, and therefore the learned trial court rightly granted mandatory injunction, thereby directing to restore the possession. The documents on record are supporting the contention of the plaintiff of having exclusive right, and therefore the plaintiff is entitled for mandatory relief. Stop.